As far as the process for appealing significant disciplinary actions, and that's a suspension, demotion, or dismissal, of course, 10 days is all you have to file an appeal after the effective date. So once you go through the investigation, which you should be involved with the member right up front, like we've talked about, the investigator will prepare a report, submit it to Inspector General Conway for approval and review, and then that's forwarded to your institution for a determination of what level of discipline, if any, is appropriate. Usually the member should receive a copy of a memo that the IG's office releases once their investigation is done, so that the employee or member has some idea of where the investigation is. It doesn't always happen that way. Usually what they'll receive next is a copy of the memo from the warden saying the allegation has been sustained and that a specificity of charges is going to be issued, which may or may not, but that's as far as the institutions seem to be doing these days. And then it goes to the director's office and the Attorney General's office for review as far as what the disciplinary action will be. Again, they try to have some consistency, but that doesn't always happen. If it's a specificity of charges for something major, then that will be presented to your member. That is in writing, of course. You don't technically need to represent the member just to receive a disciplinary document like that. Usually they're pretty good about presenting it to the member on duty. We have seen them mailed to members at home. If they're on administrative leave or sick or whatever happens to be, don't want to bring the member back in depending on the nature of the allegations, etc. But we need to have that. As soon as a member receives a disciplinary document, you need to get it to my office so that we can come up with a game plan. The specificity will include an effective date as far as when the discipline is going to be imposed, and there's also a pre-disciplinary hearing that will be on the front page of that notice. The pre-disciplinary hearing is just an internal check by the department. They'll have another administrator give the member and a representative the opportunity to explain the member's position on the allegations, and the pre-disciplinary hearing officer may or may not do a little investigating him or herself, and then present to the director a recommendation as far as whether he or she agrees with the recommended discipline of the employee. That's all it is. It's nothing binding on the director's office as far as whether the disciplinary action should or should not be upheld, but sometimes we do get favorable outcomes from the pre-disciplinary hearing officer that are helpful in, if nothing else, resolving the case before it ends up at a state personnel hearing. After the pre-disciplinary hearing, the director's office should issue a letter either upholding or possibly reducing. We have had that happen in the past. The disciplinary recommendation, and that's all it is. A specificity of charges is a recommendation for discipline. The effective date is what makes it, what imposes it, and then the effective date is also what starts the 10 days running as far as an appeal goes. So keep that in mind, that if the appeal is not filed with state personnel within those 10 days, and it can't be filed before the effective date, it's 10 days from the effective date, that if that's not filed, then they have to serve or accept the discipline, and there's no right to appeal after those 10 days. As far as the appeal goes, once the appeal is filed, the state personnel will appoint one of the state personnel hearing officers. There are 2 up north and 2 down south, I believe, right now. The experience of those officers varies. The luck, I guess, we've had with those hearing officers varies as well. We've had some very good decisions out of at least one of the northern hearing officers. The southern hearing officers don't seem to care too much about the disciplinary actions. They 9 times out of 10 will uphold those disciplinary actions, but again, it depends on the facts, of course. You know, a lot of times if it's something that goes to hearing, the facts aren't that great for the member, so we just have to present it to the best of our abilities as far as making it a favorable position that the hearing officer may end up agreeing with, but it's one of those things. The hearing officer obtains a copy of the entire personnel file from state personnel for the member, along with the specificity of charges. So, and anything related to that. A lot of times the department will include the exhibits and those documents from the investigation and attach them to the specificity so that the hearing officer has that background as well. Of course, we're not limited to just those documents and can certainly develop our own exhibits for the hearing. Once the hearing officer is assigned to the case, they will usually contact my office if I'm handling the matter, which specificity, of course, usually 9 times out of 10. The grievance committee of NCA decides whether I'm going to be representing the member or not based on the nature of the allegations. And if I am, we'll schedule a hearing 9 times out of 10 again. That's 3 to 4 months out these days, just because the hearing officers are so busy. Certainly I'll accommodate, especially a termination if somebody's sitting there out of work. We don't want them out that long, but because the limited number of hearing officers and they're all practicing attorneys with their own caseloads and clients, it's been, right now we're looking at April and May dates for a termination that was just imposed last month. So it's one of those things that by statute it's supposed to be within 30 days, but if the hearing officer's calendar won't accommodate that, then there's nothing we can really do about that other than complain to state personnel to possibly get some more hearing officers to hear these cases if they're getting that busy. Of course, we'll be meeting with the member again to prepare for the hearing once we get a hearing date, to go over things, to develop witnesses, exhibits, things like that we can present at the hearing. The hearing's an informal trial in essence. It'll be at one of the state conference rooms. They have a recording device that takes down all the testimony. The Deputy Attorney General will be representing the department. I'll be there for the member. Certainly if the rep wants to sit in on those, and I encourage that. I mean, any rep that was involved right from the start that was involved in the investigation, if disciplinary action is taken and it goes to an appeal hearing with state personnel, I'd encourage to have the representative there, both for my benefit to have some knowledge there from the institution and, just moral support for the member if nothing else. And just to see the process for the representatives, I think how the whole thing ends, in essence, is beneficial as well, so that you all have some idea of where it's headed, if it does go that far, to see how the process works. We talk about preliminary matters at the hearing. The attorneys do all our legal stuff and try to get witnesses lined out, exhibits all agreed upon ahead of time to simplify things, and then give opening statements to the hearing officer. The hearing officers do like a little summary of our respective positions, why the state's recommending the discipline that it's imposing and why NCA and the member believe that the disciplinary action should not be imposed. Then witnesses are called, just like in court. They're sworn to testify under oath truthfully, and that's always an issue, and usually an issue as far as credibility goes, that a hearing officer will make a determination on if there's inconsistencies between witnesses, and usually it's the state's witnesses compared to our member. So that's one of those things that why you have to encourage that frankness right up front to get the right information ahead of time, and hopefully some consistency throughout the investigation and at the hearing, because the deputy AGs seem to be calling the member as their first witness rather than using their witnesses, their documents to prove their case. They have the member testify first to basically put the member's version of things on the record first to the hearing officer, and then bring in the other witnesses, the other exhibits, to contradict pretty much everything the member just testified to. And I can't object to that. It's not any type of constitutional privilege that you can take in an administrative hearing not to testify. So if we don't call the witness or the member, the state's going to, and the state usually does that first, like I said. There are objections, just like you see on TV, during the testimony. If there's something that's totally irrelevant to the case, something that shouldn't be discussed in the hearing, I can make an objection, and the hearing officer, while the technical rules of evidence don't apply, the hearing officer can uphold an objection if there's a basis for it. Then I can cross-examine all the state's witnesses. Then it can go back and forth a couple times if that develops further questions by the deputy AG. We go through the exhibits, go through all the witnesses. It usually takes at least a day. I've had some hearings take more than that, based on the nature of the allegations, once again, and how complicated they may be. And then at the end of the day, summarize the testimony and the witnesses, the exhibits that were presented to the hearing officer, give some legal authority for why we think the disciplinary action should be overturned, and submit it to the hearing officer for a decision, which should be within 30 days after the close of the hearing. If it is a very complicated case, the attorneys and usually the hearing officer will want a closing brief rather than closing oral argument, which takes a couple days, possibly weeks, to present and prepare the closing brief to the hearing officer, which extends that 30 days until the briefs are actually submitted. The hearing officer can only uphold or overturn the disciplinary action. If the disciplinary action is overturned, he or she can make a recommendation for what he or she feels is appropriate discipline under the circumstances, but the department doesn't have to go along with that. So if the disciplinary action is overturned, it goes back to the department for another determination as far as what less severe disciplinary action should be taken against the employee, and we start the process all over again. So if it's something that we still think is too severe, then the employee can file an appeal once again. We go through the same process. Usually it doesn't go back to another hearing, but that's what the employee is entitled to. Usually we're able to resolve it short of that based on the hearing officer's initial decision. And then there are very limited grounds for appealing a hearing officer's decision, and that again is to district court through a petition for judicial review. NCA has taken that before, both on an unfavorable decision from a hearing officer, and the state has filed appeals before on a favorable decision from a hearing officer, which the judge doesn't have a new hearing. All the judge does is, based on the information, the record from the hearing, the exhibits, witness testimony that's all taken down, can decide whether the hearing officer exceeded his or her authority as far as imposing or issuing the decision that he or she did. And of course, that can go to the Nevada State Supreme Court as well, although I don't believe NCA has ever taken one that